Hello, and welcome to the third part of the history of juvenile justice. This is Dr. Bryson. In this video, we're going to look at early reforms. Early reforms. In the early part of the 19th century, the U.S. saw an upsurge in progressive movements. Several societies for the betterment of the community were established. For example, in 1823, the Society for the Prevention of Pauperism was established with the goal of addressing the problem of, quote, dirty, foul-mouthed children who thronged the city streets and subsisted on picking pockets and other crimes, end quote. 2 years later, the Society for the Prevention of Juvenile Delinquency was founded. Notice the focus on prevention. Organizations such as these established houses of refuge in Pennsylvania, Massachusetts, and in New York. The houses of refuge were designed for neglected, abused, and delinquent youth. Unfortunately, children who were victims were housed together with older children who were perpetrators. In most instances, the houses of refuge were worse on the children than their home environments. The belief of these early reformers was that juveniles could be saved through hard work. In West Virginia, the Industrial Home for Girls and the Industrial School for Boys was established in Salem. The Salem Industrial Home and School continued in operation until approximately 2012. The earliest of the reform schools, as they came to be called, was the Lyman School for Boys in Westboro, which opened in 1847. 8 years later, the Industrial Home for Girls opened in Lancaster, Massachusetts. It should be noted here that the doctrine of parens patriae and the earlier reform schools firmly separated adult and juvenile justice systems. Perhaps the most important case relating to juvenile justice was the case of Ex parte Kraus of 1838. Mary Ann Kraus had been placed in the Philadelphia House of Refuge by her mother, who petitioned the court claiming she could not control her daughter. When the father learned of the situation, he petitioned the court claiming that she had been incarcerated without a trial and had committed no crime. The Pennsylvania Supreme Court compared the ideal of the House of Refuge to the reality of Mary Ann's parents and concluded that parens patriae applied in this case. The court held, again quote, the right of parental control is a natural but not an inalienable one, end quote. This sentence from the case decision recalls the Declaration of Independence and its claim that human beings have certain inalienable rights. The Pennsylvania Supreme Court concluded that parental control is not one of those inalienable rights. The reformers proclaimed that they had the best interests of the child in mind. However, not everyone agreed. The year 1870 saw 2 cases in state courts that challenged and appeared to overturn the concept of parens patriae. In New York, the state Supreme Court held in People v. Turner that the doctrine of parens patriae should only be used in extreme cases. The O'Connell case in Chicago is perhaps one of the most significant cases related to this doctrine. In 1870, Daniel O'Connell was 14 years old. The Cook County Sheriff's Office took him into custody for being in danger of becoming a delinquent. He was placed in the Cook County Reform School. His father appealed the case all the way to the Illinois Supreme Court, and the court held, begin quote, even criminals cannot be convicted and imprisoned without due process of law, without a regular trial according to the common law. Why should minors be imprisoned for misfortune? Destitution of proper parental care, ignorance, idleness, and vice are misfortunes, not crimes, end quote. The court's decision effectively squelched what the child savers had been trying to do. They believed that children needed to be saved from themselves and their environment. Enter the child savers. So who were the child savers? The movement was made up mostly of wealthy women with influence on American policy. This group of women had established the Settlement House movement, the National Congress of Mothers, and the Women's Christian Temperance Union, among other organizations. This group, that was a mix of progressive and conservative women and men, was eventually able to get prohibition in the U.S., which lasted for the decade of the 1920s. The child savers argued for a juvenile justice system that was completely separate from the adult system. They claimed that all they wanted to do was be more humane. In order to achieve this, they believed the system should be inquisitorial rather than adversarial. It should be noted that the child savers actually created the concept of juvenile delinquency. There was a subset of child savers that we can call the black child savers. This group of individuals operated more in the southern United States, where slavery had legally ended in 1865. However, Southerners found a loophole in the laws created by the child savers. They took black children from their parents, claimed that they were giving them an opportunity to learn a skill, and simply re-enslaved them under the color of law. In 1969, Anthony Platt published a book titled The Child Savers. Platt argued that the child savers were not as benevolent as they claimed to be. He noted that the child savers believed that juveniles needed firm control. He also noted that decisions were based more on the values of the upper and middle classes than on the needs of the child. This distinction between a child that might be dependent versus a child that might be delinquent was blurred. Because of the Illinois Supreme Court decision in the O'Connell case of 1870, the child savers had their hands tied. They continued to lobby, and in 1899, the Illinois legislature passed the Illinois Juvenile Court Act of 1899. This bill created the first legislatively established juvenile court. Memphis, Tennessee claims to have established the first juvenile court, but it was an ad hoc court that operated without legislative powers. Juvenile court was drastically different than adult court. As with all government policies and programs, the reality of administration was drastically different than the ideal of the reformers. What were the ideals of the juvenile justice reformers? They believed that juveniles are different than adults in that they are more malleable. That means that a delinquent act may not be the established character of the individual. Their goal was to provide rehabilitation, not punishment. They believed that juveniles must be saved, not punished. Because of this belief, they saw due process rights as unnecessary. The thought was, if we care about the best interest of the child, then due process rights are immaterial. But there were practical implications of these reforms. First, as noted, juveniles were denied due process rights. Second, the system that was established could easily be used as a method of social control. Third, the concept that the state could become the parent expanded into other arenas. For example, in the late 19th and early 20th centuries, eugenics resulted in forced sterilization of the feeble-minded and morons. At the time, those were diagnostic terms. We will see you next video.